It protects you from a whole lot of things. In our latest lawsuit, we put in there that the company refused to answer. And now can they say that the lawsuit was frivolous or without merit? Now, after it's been filed? We offered to sit down and negotiate or discuss. If our suit was without merit, fine. Then they should have sat down with us, and we told them in the cover letter we wouldn't file a lawsuit in U.S. District Court if they can show us that our suit was without merit. So now you take this, and it becomes part of your evidence for when you file it down here in U.S. District Court. If they won't sit down with you, they won't explain to you where your lawsuit is frivolous, then you have no choice but to file that lawsuit. The judge cannot impose penalties on you, cannot impose sanctions, anything else because of that cover letter. And the fact that you took all that in and offered to negotiate in good faith with them. Because they showed bad faith. They have dirty hands. The company has dirty hands. We know that, don't we, Bill? Just like half the lawyers in the world have got dirty hands. Maybe all of them. But so that is a hugely big, important procedure. You should absolutely use it every case.
At what point in time do you mention, at what point in time do you put in there about the amount of money you're suing for?
Well, that's in your complaint. That's stated in the last part of your complaint. I'll go through the what a complaint, what the purpose of the different sections are. Okay, and it's a very logical process. So what I'm asking you to do is look at this whole procedure, court procedures, the writing of a complaint, as a very logical, mechanical process. If you've got all the laws and facts on your side, you should be able to win that lawsuit, unless there's some other issue like immunity. And believe me, if they don't act in good faith, they have no immunity. Even the highest government officials. The first case I told you I filed, that my evil lawyer on the other side, he cited 48 United States court cases. He just cited them. He didn't tell me. All he said to the court was that these cases show that the government had immunity. And this was supposed to apply to the county in Michigan here. So I said, I called him up. I said, well, I would like to see those cases. Would you provide me with those cases? He said, I don't have to. Okay. I said, well, and I was brand new at it. You know, I never run into this before. So I said, well, I'm going to go up and I'll check out all those cases. And I did. I got copies of all those cases. Everyone was like the Nixon administration when everybody was suing Nixon and Haldeman and Ehrlichman and all these people. The courts, the U.S. Supreme Court ruled that in every one of those cases, if the government agent acted in good faith, they had immunity. But if they didn't have immunity. Haldeman, Ehrlichman, all these top administration officials. And good faith means that if you get somebody makes an allegation against you and properly delivers it by certified mail, or like if you deliver your complaint to them and they refuse to answer that, that's not good faith. That's fraud. So I want you to understand the process and what we can use to really bolster our case in the face of a judge who's going to be hostile to us automatically because we're not a government official and the defendant is. These boys are playing the old boy game. A lot of these public officials don't honestly know the truth. They're no more educated than high school dropouts. But they think because somebody gave them a title and an office and a salary that they could do whatever they wanted. A lot of these people honestly believe that. And until you walk in and you confront them and show them the law, then they stare and they get panicked, they go into shock, they go into disbelief. I'm telling you, I've seen clerks in our township go into panic when I walk in their office. And I'm just going in to pay my bill. And I've never been impolite to any of the clerks in my township. I don't want to be impolite to judges, lawyers. One time, my evil genius lawyer, I was insulting to him out in the hall. He said, "I win all appeals that go to appeal." I said, that's only because you've only done them against lawyers. You're dealing with pro se. And he turned on his heel and walked. But I mean, I consider that was a slap in his face and an insult. And I think he deserved it. I think he deserved it.
I think you're polite.
That was very polite, actually. I don't know. Maybe someday I won't be so polite. I don't know. I'm trying to get myself toughened up to all this stuff.
How can you be impolite when you're talking to a lawyer?
I don't know. Call him an SOB, I guess. That would be
That would
impolite.
be a compliment, I would think.
Okay. An elevation of status, right?
Upgrade.
Yeah. Yeah, well, anyway, this is what you got to do, and this is a procedure lawyers don't use, but we can. We present this to the guy we're going to sue, and we say, if you got reason to explain to me why this lawsuit has no merit, or if it's frivolous, or if you can show us why even one single paragraph of this complaint is false, misleading, erroneous, show me before I take it into U.S. District Court. Then, if you can show me that my case is a lousy case, I won't file it. But I want you to sit down and talk to me. You refused to talk to me up to this time. Now you got the choice. You either sit down and talk to me, or I go to U.S. District Court.
How do we know which district court to go to?
In the Western District of Michigan.
We can pick
No. There's
your area?
No, you go to the federal U.S. District Court of the Western District of Michigan.
Oh.
Now there's only two sitting judges left there. One's a retired senior judge. One's a magistrate judge. I think all the others have vacated their office, but you can pretend like they're still sitting there if you want to file a lawsuit in there. Or you can go to the Eastern District of Michigan and say, I can't file in the Western District of Michigan until we get our sitting judge there.
Is that because of your work?
Yeah.
Good.
Really?
Well, yeah, we notified Congress. I notified every one of the judges that they repudiated their oath of office by their actions.
You're still sitting in court.
I don't know. I just notified them about 2 weeks ago. And they won't respond. But we're now taking it to Congress. So far. But now we're going to Congress. And we're notifying Congress that you have to get us replacement judges in here. So we have a operating, functional U.S. District Court in the Western District of Michigan. And if you won't supply us with these, we'll elect our own judges. Because we are entitled under the Constitution of the United States to have an operating, impartial U.S. District Court in the Western District of Michigan. Now, you could use the same procedure in almost any other part of the country. California does, these judges, if they're not going to uphold the laws, now you have to understand there's two oaths the judge has to take. He doesn't just take one, like the average official. They take the first oath, which is to swear to uphold the Constitution of the United States and the laws of the United States. Now that's the first oath they take, and all officials will take that one. Second oath is the one that says, I swear that I will be fair and impartial to all litigants, all parties. I will show no favoritism. Now, if you could prove that they violated court rules to your detriment or violated your due process, then they violated that oath of office. And they vacated their office. De jure and de facto. The Latin means concerning the fact, de facto, it's just a fact that they've done this. De jure means concerning the law. The law is, in other words, they've sworn to take an oath to uphold the Constitution and to be fair and impartial, and then they repudiated it later when they came to your case. Because you're special. Yeah.
All right, the first one's in 5 U.S.C. 3331. I think that's the all officials oath.
Okay.
Do you happen to recall from memory where the other oath can be found? Because they give a sample.
What title was it in?
5 U.S.C. 3331.
5 U.S.C. Okay, that's 5 U.S.C. I think the other one is in either 18 or 28 U.S.C. Title 18 or Title 28. I'm pretty sure, and I think the section is around 453 or something like that, if I can remember. But it's there. It's at what all judges must do.
How do you enforce them out of their office to vacate? Do they just ignore it and just keep on doing their...
Well, that's why we're going to Congress. We're going to force Congress. Congress must uphold the laws of the Constitution. Now, if we can't find one congressman that will uphold the laws in the Constitution, we'll vacate the congressman. Okay, we have to pause just a second.
Go ahead, you have some.
And we'll go on to tomorrow. And remember, tomorrow we're going to do the court rules. And you're going to like the court rules. They're very nice, very good. And the judges break them all the time. Guess what? Oh, do you have that running, Kim? Okay, we're recording it. The court rules are really your due process of law. They're to enforce your due process in court. So, in other words, if the court rule says you can file a motion concerning scandalous material filed by your opponent, that means you have that right. It's not a privilege that the judge may deny you. Judge Carmody denied my right to access that court rule. So she denied us our due process. And in doing that, she vacated her office. And you know what? The judges don't like this at all. They really do not like this. But I'll tell you what, it's the way to get it done. We're trying, let me just digress here for a minute. There's a lot of groups out there that advocate violence. They advocate disobedience. They go out and carry signs, whatever they want to advocate. We do not want to destroy this country. This country, we have a great system of laws. We simply have let the lawyers do our thinking for us. Now we are individuals who know something about the law and know how to use the law properly. And we know how to call the lawyers and the judges down when they violate those rules, regulations, laws, their oaths of office. We know how to call them down on it now. We don't want to destroy this country. I don't know, actually, I don't know if You know, I don't have a crystal ball. I don't know what's going to happen in the future. I see some very bad things happening right now, but I also see a lot of good things happening. And I'll tell you what, the Lawman is the leader in the country of all the tax movement groups. We're the leader. We're the ones that go on the offensive. We're the ones who study the law and how to learn the law and how to use the law. It's not, you know, all these other groups, they're sitting around in their coffee shops having mocha coffee and griping and moaning about how bad things are. You can debilitate yourself by just sitting around griping and moaning. I am convinced that so many people are so tired all the time because they're so angry and frustrated. They don't know what to do about a situation. And instead of focusing their energy on solving the problem in a good, legitimate, lawful way, they're too, I don't know, maybe they don't believe it can be done. If a person doesn't believe it can be done, believe me, for that person, it'll never get done. That person can believe he's totally incapable of acting lawfully and legally and applying the laws to the officials. But if he believes that, it'll become a self-fulfilling prophecy. So do not fall into that trap. Do not fall into the many other traps that the patriots have done. Let's just do what we need to do. We know what has to be done. Okay, now this is now what are we doing here? Are we on defense or offense?
Offense.
Okay, we're playing offense here. We're filing a complaint, sworn statement, evidence, and brief. Now we get to U.S. District Court, we file it. We actually file it. Now they have to provide an answer. And they'll have a brief along with their answer. Now the brief, as I explained, is really a compilation of case law that applies to this case. So what the lawyers and judges have played the game, they won't quote from the case, they'll just cite the case. In, I think it was Judge McKeague's case. Judge McKeague didn't play the adversary system of law. He acted as a lawyer for the defendants. He cited case law for the county of Ingham, which we're sitting in right now, and to protect the prosecuting attorney and the sheriff of Ingham County from wrongdoing. Those people are criminals and are involved in criminal activities. I have no problem saying that. The judge was running cover for these two guys because Judge McKeague was at one time a district judge in the county of Ingham County. He was a state judge. So these are all his cronies.
That was Judge Bell. Judge Bell was a...
So was McKeague, a district judge here in Ingham County. Both Bell and McKeague.
I wasn't aware of that. I knew Bell was.
Okay, maybe I'm wrong. But anyway, it's still a cronyism and a favoritism they're giving to all the official entities like Ingham County, the sheriffs, the local prosecuting attorneys. Bill had an airtight case. It still is an airtight case. Bill could vacate that judgment anytime he wants, but we have to get a sitting judge in this county, or in this Western District of Michigan. We can't file a new case until they give us a new judge that won't violate his oath of office, so we have to notify Congress of that. But McKeague, since McKeague's out, they'll probably appoint a new judge for this Western District of Michigan, and then we can refile whatever we need to do. But this is what we have to do. We have to call down every judge every time they step out of bounds, every official when they step out of bounds. And let's not be timid about it. There's no point being timid. I'll tell you what I've seen with the IRS. The IRS attacks mostly two kinds of people. People that don't know the law, don't know court procedures, and those people a lot of times will identify themselves by putting brackets around their zip codes. Or they will say, in care of such and such. They won't have an address, their address down. Or they'll have a dash between their first and their middle name and a colon between their middle name and the last name. And they think that's somehow going to protect them from the big boogeyman out there. I tell people, look, there's enough real dangers and enemies out there without inventing boogeymen. Okay? You're not going to protect yourself in any way by putting a dash and a colon in your name. You know what that's going to do? Signal to the IRS, here's a turkey, let's go get him.
That's what they got me.
That's how the guys do?
Yeah, that's why they're going to try to squash me like I bought.
Okay.
I bought into all that stuff.
Yeah. I've seen this time and time again. And just tell, now, one thing you need to do is square that away because, and I'm not sure how you would do it, but you'd start filing all your pleadings with just your normal name, okay? Drop the colon and the dash. Because what will happen in a court case, if you got dash and colon in your name, you know what's going to happen? A smart lawyer will say to the judge, this man's concealing his true identity. This man is perpetrating fraud in the court. And you know what? I want this man to produce all his records showing his real name on the record. His pay stubs, mailings from banks, bank statements, everything. And the judge will say, yeah, because we have evidence, we have probable cause to believe that you are using a false and fictitious name.
Oh, but Your Honor, it's just a typo.
That's, you could say that, and Your Honor would say, oh, Mr. Typo, Mr. Typo, I have about 4 documents here. You made the same
I got a real
type?
bad typewriter.
Okay, I'll tell you what, you'll probably still want to grab all your records and everything, and then when they look through your records, they'll try to go on fishing trips for all your records.
Yeah.
That's what they try to do, and fishing trips, we never should allow a government agent to go on a fishing trip through our records. I'll give you an example of what you can do. There's little things that are your lawful due process rights. One is the Miranda rule. Anybody remember Miranda? Okay, Miranda says they can't question you unless you have the assistance of counsel present. Okay, so now, if you say to the officer or whoever's questioning you comes to your door, you say, what is it you want? Don't run from them. Don't run from them. Treat them with respect and everything. What is it you're doing here? He said, well, we have evidence that you've committed a crime, or evidence of some violation of an ordinance or something like that. Oh, what evidence is that, your officer? Well, we'll show you that when we get you in court. Oh, well, officer, from now on, if you have any questions for me, please put them in writing. And if I need the assistance of counsel, I will go seek assistance of counsel. But until that point, put your questions in writing, go back to your office, write them up, and send them to me, and I'll answer them.
I just want to say something that happened to my son a few years back. He was in an accident here in Ingham County. And one of the kids in the accident was hurt, so we took him to the hospital. Well, the Ingham County, somehow somebody called in the accident, and they got my son's license plate number. And this sheriff showed up to my house about 4 times within 3 hours. I mean, just kept coming back. Just kept talk to my son. So when my son got home, I said, don't talk to anybody. Write down what happened to the accident. Fill out your own accident
You
report on.
shouldn't do that though unless
No.
you have the counsel.
So he wrote down just what happened in his own way and took it to the Ingham County Sheriff, because he was reporting the accident. He was required to report the accident. And he gave it to them, and the officer behind the desk said, "We have some questions for you." He says, "No, you don't." He says, "All of my answers are right on that document. If you have anything other," he says, "give them to me in writing and I'll see what I can do about answering." And they never bothered him again.
Never bothered him again. See,
But he didn't answer any of their questions either.
right. Well, actually, I had a police officer come up to my door, and he said, "Well, can I come in? I'd like to ask you a few questions." I said, "No, you may not come in, but I'll put on my shoes and my coat, and I'll be right out." So I went out there, and then the minute he started asking me questions, I said, "Well, I'll tell you what you're going to have to do, officer. You're going to have to write down all your questions and send them to me in writing. And if I need counsel, I'll seek counsel." He said, he said, "Well, I'm just going to give you a warning." It went from a criminal thing to a warning, okay? He says, "But don't do that again." I said, "Officer, I will take everything you've told me today into consideration." In other words, I didn't admit anything. And he stopped and he looked at me and he like, who the hell is this guy? Anyway, he repeated it. And I said, "Officer, I told you I will take everything you've told me today into consideration." So I made no omission, nothing. And he wasn't about to go back and put all his questions in writing, because I could turn those questions on him in big time ways. And he knew that he was dealing with somebody that wasn't ignorant about the law. And which goes back to my original point. The IRS people will pick on people that are ignorant or weak. Another thing. If they think you can be hammered into submission, and you got to have some assets they want to get. Okay? They want your assets too. If you have no assets, you're not going to be able to do that.
They want your ass too.
Okay.
I thought he said.
That's just a little lower.
Okay. But anyway, that's kind of what we need to do in this whole business. But you need to be aware of some of the procedures, your rights, your Miranda rights. You need to know what your rights are. Remember that preliminary hearing. You have a right to the information you are requesting from the county. Say if you have a traffic ticket. If he won't give it to you, you say, "Okay, I want discovery." And the judge has to issue an order for discovery on those issues. And you never go into a hearing without your request written down on paper. That way you're not going to get flustered and flubbed. You're going to throw it at the, say, "These are my questions for you. Please answer them for me, one at a time." And he said, "No, I'm not going to answer these for you." "Okay, then I'm going to ask you for a discovery order from the judge. If you can't give me the answers to those, if you can't provide me with those documents, I will ask for a discovery order from the judge."
What exactly is that?
Pardon?
Discovery order.
Discovery order is an order from the judge says that you are entitled to a period of discovery. In discovery, you could file 3 things for discovery. One are interrogatories, which are simply questions that they must answer under oath. Secondly, requests for admissions. So you say, "Do you admit this? Do you admit that?" Yes, no, yes, no, yes, no. So you're nailing them down more and more. Thirdly, you can do a deposition on the agent or the officer. And they hate this because they just wanted you to come in and pay your damn money. And now they've got, the officer's got to come off the job, go to a deposition, answer all these questions, and you're accumulating all this evidence to use against them in the case. That is your court procedure, preliminary preliminary to trial, and it is your right to have discovery, even in a traffic case. I sat down one time with a assistant attorney, prosecuting attorney in Battle Creek, and she's a very nice lady. And I said to her, can I have discovery? She said yes. Okay. So she, by acceding to that, agreeing to that, stipulating that I had the right to discovery, I could have then done all my filings in that case.
I got discovery on a zoning ordinance.
Right.
Case. Or no, a building ordinance.
That's right.
Case.
And who won those?
We won.
Yeah.
Discovery is gathering information
That's right.
from the other party.
And they can do the same to you.
So that's part of the preliminary.
Yes, because here's the way our system of law works. Before you actually go to trial, you are supposed to know all the facts and evidence that they are going to use against you. And you have to present all the facts and evidence that you are going to use against them. So they can ask for discovery against you, and you can ask for discovery against them. Believe me, I would love sometime to get one of these officials in a deposition on a recorder. Because a deposition has the advantage that they can't do evasive stuff. You know, you ask him a question, he answers with a non-response. You say, no, I didn't ask you that. I asked you for your delegation order from the Secretary of the Treasury. Do you or do you not have a delegation order from the Secretary of the Treasury? You say, oh, I don't know. Well, let me ask you, have you ever seen a delegation order from the Secretary of the Treasury? Well, I don't remember. So in other words, you're saying that you're operating under as a delegate of the Secretary of the Treasury, and you don't know if you've got, have the delegation from the Secretary. Is that right? Well, you can assume anything you want. So anyway, your questioning would go like that.
A type of interrogation.
It's an interrogation. But see, this is what you're going to ask them on the stand. This is why I say that the mechanics of our legal system is really good. Uh-oh.
So it could be a type of rehearsal.
Yes.
And help you.
Oh, yes. In fact, surprise is forbidden by court rules. You go into trial and they pull a surprise on you. You say, Your Honor, this is forbidden by, this is barred by rule such and such of bringing ambush by trial, or trial by ambush. It's a legal term. You'll find trial by ambush in this little book, this legal dictionary. It says it's frowned on by the courts. Actually, it's forbidden by the court rules. Court rule, I don't know if it's Rule 60 or something like that, but we'll probably get into that tomorrow. Says they can't surprise you at trial. It's not admissible at trial if it's a surprise they pulled out of a hat and they didn't tell you they were going to present it at trial before. In other words, look at like the movie.
The one that you and I saw?
No, this was a different one. It was where that little guy was the lawyer, I think.
Oh yeah,
anyway,
sure.
So he comes into town and he talks to the opposition lawyer or the prosecutor, and he says, well, we have to lay everything out on the table. That's exactly what you have to do. And isn't that the just thing to do? Isn't that enforcing your due process in court so that they can't all of a sudden pull something out of a hat on you? It is. Now, you administratively talk to the IRS agent, say. Then, say he's a local IRS agent. That's the best of all circumstances. If you've got a local guy, then you can have this served on him. It'll only cost you like $30 to have it served on him. But then you've got proof that you served it on him. And then you have that cover letter on, offering him the opportunity to sit down and tell you why your complaint has no merit, or sit down and negotiate with you. Then you file it in the U.S. District Court. They answer with an answer and a brief. But they should have provided that up here before you went to U.S. court. That's just. That is our system of law. So now the judge cannot say that you did not exhaust all your administrative procedures, because that was your exhaustion right there. You said, you sit down and talk to me. You and your lawyer, your supervisor, whoever you want to call in as witnesses. Sit down and talk to me. If you won't do it, I have no other choice but to file in the U.S. District Court. So, you get this back, you're going to have to answer everything. You can't let anything slide by. You have to parse all their words and all their statements. Just like that 7433 argument that they usually throw out. They'll also say that the IRS agent has immunity. Well, that's baloney. You cite Galagos versus that New York case. And when you cite that and other ones, that they don't have immunity when they step outside their lawful authority. So you have to answer those questions. Now, in a brief, let's just go through a brief. What the layout of or a complaint, complaint.
Chuck, why do you have to answer their brief if it is essentially defaulted on your statement in the first place?
You shouldn't have to, but believe me, better.
Okay.
I agree. I think the case should be won right at that point that you file. But, and if you have an impartial judge, the judge should ask the IRS agent, why didn't you answer? That's fraud right there. You lose. Well, unfortunately, we don't have really good judges.
Needham speaks last.
No, not necessarily. No, you have to have the facts and the law on your side. If he has no law and no facts on his side, he loses. That's why I say look at the whole procedure as a mechanical process. You're going to put up your law and your facts. And if he can't rebut them, your law and your facts stand. Ask him. And when you respond, you can do a counterclaim against him. I learned that from my evil genius lawyer that I was up against in my first case. He filed about 10, 12 counterclaims. And you know what? I almost didn't catch on. I was reading the court rules and reading them. I almost didn't catch on. But the court rules say that if in a counterclaim, if you do not respond to each and every counterclaim and either deny it or say that, or explain that there's not enough information on which to make a determination, then you are admitting. And if you admit even one of those counterclaims, you lose your case. I'm sorry, that's wrong, but that's the way it is. So that's what I'm telling you. When you get a counterclaim, or if you do a counterclaim, they have to answer it. But if they do a counterclaim, you have to answer it. So let's put a counterclaim that you might do a response. The next step is a response. And then the counterclaim can be, it's like an add-on. It's not included in your response. This is an add-on thing. You don't have to do a counterclaim. But I'll tell you what, if you got a counterclaim, you should do it. And you label it as a counterclaim. You do your response, you get down to the bottom, and you make your prayer to the court at the bottom of your response, and then you file a counterclaim, and then you make a prayer to the court at the bottom of your counterclaim. Based on these counterclaims, I ask the court to proceed with our case to jury trial or into discovery. The counterclaim could be that the IRS agent is afraid and refuses to present me with his delegation order from the Secretary of the Treasury. The IRS agent cannot show me a statute where he is authorized by title to do anything with subtitle A or subtitle C of the income tax laws. So the counterclaim is very powerful. I did it in the case, our lawsuit against the IRS, and the judge never answered. But, you know, the judge just bypassed everything, said, I'm dismissing. And so we could go back in and vacate at any time. Now, the one thing about a vacate, you can do it at any time, even 15 years later. So if you get your case dismissed, you can do a vacate. Now, the way you do a vacate is you go and read the court rulings from the Supreme Court and our precedence law. It'll tell you why a judge may not dismiss the case unless certain conditions exist. And you cite those precedence laws at the judge. You say, I want you to vacate your decision to end my, to dismiss my case. So now, we're talking about jurisdiction. You originally established jurisdiction when you filed your complaint in your brief, right? In your evidence, in your sworn statements. That established jurisdiction in the court.
What if they challenge it right away?
Fine, let them. On what basis?
Let's say that I didn't,
Serve it properly?
no, it was that the tax court has jurisdiction because I didn't, because I received, they cited 6330, 61, where...
No, because if you look at tax court, and I've got that right here, I downloaded it the other day. You can go either to tax court or U.S. District Court. Both. I've got it right here.
Yeah, okay.
Okay.
They're saying that that court doesn't have jurisdiction.
For what?
U.S. District Court doesn't.
Are you the plaintiff or the
I'm the
defendant?
plaintiff.
Okay, all right.
I'm the plaintiff. You're saying that district court doesn't have jurisdiction. Tax court does, because tax court has jurisdiction to decide the underlying liability or the tax.
No, they don't have.
My argument is going to be that there is no underlying liability because nothing has been assessed, and there is no tax determined,
Yeah.
and no notice of deficiency has been.
Right.
Nobody sent me something else.
And no assessment.
No assessment and no statutory notice of deficiency.
Right.
So that's my argument back that they do not have.
But see, I wouldn't go to tax court because tax court, for one thing, cannot decide the issue of liability.
Right, and that's why I'm...
Because the issue of liability is a constitutional issue. You have to go to a, not an administrative court, which is what tax court is. You have to go to a U.S. District Court. Now, in the Internal Revenue Code, the appendix onto Title 26, I've got that right here. It says you can petition to either U.S. Tax Court or U.S. District Court. The IRS people don't tell you can go to U.S. District Court. You know why? Tax court is an administrative body set up for employees of the government, internal to the government. They're not set up for handling controversies of constitutional issues. I would never go to the tax court.
I don't want to go there.
No, because it's a rubber stamp deal. By admission, if you go to tax court, you're almost admitting that you're a federal employee. Because where is tax court located? Is it located out here in Michigan?
No.
It's located in Washington, D.C. I know two guys that drove all the way to Washington, D.C. to go to a hearing in tax court. I thought that was really dumb. I mean, why would you do that? Court's supposed to be set up in your area. And if tax court did that, I don't know if they could set up on state or private property in Michigan. It would have to be on territory ceded to the federal government. So even if they came here and held a hearing here, would have to be in a courthouse of the U.S. District Court, owned by, owned by the federal government. Now that's my opinion, and I think it's possible I'm wrong, but I think I'm right on that.
I have no desire to go to tax court.
Right.
District court.
Yeah. I know we wanted to bring up that issue at tax court, because people have been swaddled, or whatever you want to call it, into going to tax court, and you almost lose almost every time. Once in a while somebody wins on some technicality, but if like for instance, a lady in Georgia who's in our group, she went to tax court before she knew, I was telling her not to go. She said, well, what do I do now? I said, okay, well, file a notice to the tax court, or a request for information. Ask the tax court if they can hear the liability issue, the underlying liability issue on income taxes, because you have a brief to file with them. There it is. There's your brief. It's all done for you. All you got to do is take my name off the bottom of it. Put your name on the bottom of it. So anyway, she got a thing back from the tax court saying they were fining her $15,000 for frivolous filing. And she was really upset. And I'm warning you, don't get upset. Start using your brain, and you'll see that in all this fraud that they've perpetrated, you'll find that there's some law they've turned on its head. So I went, and the tax court had cited under a certain statute in the Internal Revenue Code. Okay, so I went into the parallel table of authorities, and I looked. That statute had no implementing regulations. So the fine could not apply to the general public. There simply was no force of law there. So I did a little research for her and sent it back to her, and a couple of other things. And I said, you use this as your main argument, and the backup argument is this, and send it to the tax court. Well, she hasn't heard back from the tax court. But they cannot enforce that judgment. Because, you know what? The lawyer for the IRS at that tax court perpetrated fraud on the court and on this lady. Fraud vitiates all judgments. And we have that in our precedence law. So the judgment of $15,000 against her doesn't exist. It was null and void from the beginning. Never existed. She wrote me back, and she was so happy. She was jumping up and down and dancing. And she says, oh, boy. Anyway, she won't hear back from those buggers. So, but you have to have confidence. You have to have confidence that if you do it the right way, you're going to win.
Vacate the same as void judgment?
Yeah. Yeah, because it was a motion to vacate the judgment authorizing a $15,000 fine on her, because it had no force of law. And U.S. versus Gorski says that. And California Bankers and Wait, W-Y-A-T-E or something like that. And then there's another big one that I have in my files, and it's a long ruling, but it has a lot of information in it, and it spells out the need for regulations, and when they won't, even if there was a regulation, it wouldn't be applicable in certain circumstances. So, but if there is no implementing regulation, you can send an affidavit to the lawyer that's representing the IRS. Say, sign this affidavit stating that such and such is the implementing regulation promulgated by the Secretary of the Treasury for this statute. You sign it under penalty of perjury. You put your name on there, Mr. Lawyer, or else you're perpetrating fraud on me, and you're concealing now evidence that can be used in this case. Make these guys accountable. They don't want to sign affidavits. They're afraid of committing perjury because a lot of people go to prison for perjury. So, how we said, it's about 2:20, so we've got probably another 10 to 40 minutes. I was going to start, just lay out that complaint so that you understand what a complaint looks like. Okay. Complaint. Now this is your written thing, and it serves the same function as a police officer when he gets you a speeding ticket. He signs it under penalty of perjury. You're going to sign this, and if you were a lawyer, if you made a false statement in there, you could be held in contempt of court. Well, I think that's in the court rules, so don't hold me to that particular thing, but I think there is something in the court rules that says the lawyer who signs a complaint or a filing in the court is responsible for all the statements he makes in there. So if he's making a whole bunch of false, misleading statements, he's responsible for it. He can be sanctioned. So you got a cover page, and that includes the court, the name of the court, the case number, and they will assign a case number to the complaint when you file it in U.S. District Court. The lady will take the 2 copies you provided for the U.S. District Court, and she will stamp on there the case number. And on your copies, you'll have 2 copies for yourself, one for the defendant. You're going to serve that copy on the defendant. And then she will write out, assign a summons to go with the complaint. The complaint is no good without summons. So make sure you do complaint and the summons. Now, we'll just put on here and summons, so you remember that. I had one of our servers out in Kansas City serve a complaint without serving the summons. I says, what good is that? Anyway, yeah, Kevin.
Okay. With the IRS petition, IRS summonses 2039.
No, we're not talking about that kind of summons.
Oh, no,
we're talking about the court, U.S. District Court summons to the IRS agent.
Yeah, but I file a petition to quash their summons.
Okay.
So that's like a court complaint.
Yeah.
But on my heading.
Well, it's not a complaint. It's a court filing. It's a pleading.
Okay.
A complaint. You are complaining about this other person.
The IRS revenue agent.
Yeah. Now, if you want to start a whole new lawsuit and file a complaint against them for falsely issuing a summons, you can do that in U.S. District Court. And use that 7608 against them. 7608 is the statute that says IRS agents with all these different titles, the ones we deal with, can only do collection actions and summonses under for subtitle E, which is alcohol, tobacco, and firearms. And it specifically states in for any of the commodity taxes. So that ought to be like your #1 quiver in your arrow in your quiver. That should be always in your head. What authority do these guys have to do anything? Okay, yeah.
Okay, so instead of doing a complaint against the revenue agent, I put down petition to quash the summons.
Okay, that's fine.
But the clerk says I would not need a summons to get the agent or a U.S. attorney to answer my petition.
Okay.
Instead, the clerk says I would only have a notice of motion to get the assistant attorney in front of the judge to determine, to hear this petition to quash.
Well, the problem there is you need a case number. Did they get a case number for you?
Yes.
No, I mean, did the IRS, when they issued a summons?
No case number.
No case number.
That's invalid.
Right,
right there.
Right. Okay. Now, here's the point, and I ran into this with these folks. that they did something, a court judge, magistrate judge, issued an order for seizure of property without a case number. There's no case number, nothing. It's just saying, oh yeah, they can go in and grab everybody's property. Okay, no probable cause, nothing. No verified evidence, no sworn statements. So what we did was we filed a pleading with that magistrate judge saying that the IRS agents had committed fraud. They had no assessment, lawfully assessment. They had no liability. Our people did not have any liability, and a number of other things. Now, what happened was, all of a sudden, this Judge Barbier, who's a real judge, issued an order removing the magistrate judge from the case. But there wasn't a case. But he removed him anyway. He removed him and says, I'm going to take over this case. And I'm going to review the filings by the defendants, by the attacked people, in other words. They weren't even defendants in the case. So now, once Barbier saw that, he said, I'm taking over the case, which is fine with me. And he assigned it a case number. So now we got a case number. And that's what I read to you before. We have the case number right here. Right there, up at the top. That's why I'm saying, here's your cover page. Goes down to here, citing who's who in the case. United States of America versus him. Who the judge is, what district court it is. That's the kind of information that has to be on your cover page. And then you start in on your pleadings. And your pleadings in a complaint will start out with paragraphs. Okay, you start out with paragraph 1. And what would be the first thing, logically, would you identify in your complaint? Just give me a... Yourself. Yourself. Very good. Exactly. Yourself. You say who you are, where you live, what your status is. Now, at that point, you don't tell them all the issues of the complaint. You just tell them you're a non-corporate citizen. You live in the county of this and that. That you are entitled to all the considerations as issued in Haynes versus Kerner. You tell the court that, paragraph 1. Paragraph 2, what are you going to tell the court now? That's right. Okay, so you're the plaintiff, you're telling the court all about yourself. Number 2, who the defendant is. They work or live such and such a place. They're an officer of a corporation. They're officer of the IRS. Whatever. Number 3. Cite your jurisdiction of the court. How it is that you are stating that the court has jurisdiction over this case. So now you're the one who confers jurisdiction on the court by pleading sufficient. Okay, so I'll put sufficient pleadings. So you confer the jurisdiction in this 3rd paragraph. So now we're getting someplace. Number 4. Okay, you want to establish the facts. So now, you may have a number of facts that you want to present to the court. Like, for instance, the IRS agent never contacted you before he issued a notice of levy. The IRS agent doesn't have, has never presented you with a statute that authorizes him by title to seize your property or do anything except alcohol, tobacco, and firearms and you don't deal in alcohol, tobacco, and firearms. That's another fact. You know it from personal experience. You can put that in your affidavit at the bottom. Let's say you got an affidavit down here. Now what you want to do, is put some of your facts that you know from personal experience down in your affidavit. You're going to attach that affidavit to your complaint. So you may have a whole bunch of paragraphs with facts, but keep your facts concise and to the point. Don't ramble on. Don't talk about how the IRS agent was mean to you. It ain't going to wash. It has no legal meaning in court. It has to be a factual statement. He didn't have a delegation order. He never contacted you. He's never presented you with a assessment. He's never notified you of the assessment. He violated this law. Then you get into your laws. So you have a whole bunch of paragraphs of various violations of law. I mean, they violate almost every law on the book. I always tell people that the hardest part is to pick out the most important laws they violated. That's the hardest part with these turkeys. So you point out in specific paragraphs the laws. And you can cite court cases in there. Now what I do, and I think Richard Cornforth now uses my method here, but to back up my paragraphs, I will quote the portion of the ruling, and I will cite the name of the ruling, U.S. versus, Haynes versus Kerner, what year it was in, what volume, U.S., and then what page it starts on, and then a comma to show where that ruling is found in that case. Like for instance, let's say U.S. Versus Kerner, or Haynes versus Kerner, let's say. You're going to cite this. And you'll have that quote right in this number one paragraph, telling what U.S. or Haynes versus Carter said about a pro se plaintiff. And now the citation, you put a comma after this, then you put like the volume number, if it's 236, say, then U.S. means that it's a U.S. Supreme Court case, and then the page number, say it's page 330, okay? Now, the ruling itself is found at 345. So you put a comma, 345. If it's got two rulings you want to cite, you might want to put another comma with another page on there. But that simply backs up your argument. And it shoves it in the judge's face. We cannot allow the judges to play this stupid game they're playing. If they want to act like children, let them. But we're going to act like adults. That's the difference. We shifted the battle. They're on the run, they're hiding and ducking. We're on the offense and we're going to stay there. And we're not going to go away. We have over 4,000 people, and as soon as we can convince all 4,000 not to be afraid, we're going to have a dynamite organization. Right now, we probably got 500, 600, 700 that are not afraid. They know what they're doing, and they're willing to follow the agenda. And even the 500 or 600 is dynamite, let me tell you. Because when I ask people to send out a affidavit to this judge for these people's property, and a notice to the judge, to the court, I'll get tons of people that will say, I sent this out to the judge. And so we now have a process in place where we can really call these people down on the carpet. They're the children. They're the ones that are pretending like they're obeying the law. We don't have to put up with that anymore, and we're the adults, we're the citizens, and we're calling them down. Anyway, back up your facts and your law paragraphs with all court rulings. Sometimes I'll put 2 or 3 court rulings, and I'll quote from the case, and then cite the numbers of the case at the end of it. You'll see it time after time in my filings. Yeah, here's Charles F. Conces appears as a pro se individual, and then I cite Haynes versus Garner. My next paragraph, I cite who this man is and what he's done. He's done nothing unlawful. And then I cite Butcher's Union. Butcher's Union, Copage versus State of Kansas. Now this was in 1915, 3 years after the 16th Amendment was passed. So the judge can't say that there's anything came along that's changed Copage versus the state of Kansas. And the judge knows it. I win that paragraph. Here's another one, conferring jurisdiction. This is U.S. versus Hill. Jurisdiction of the courts of the United States. Here's one to vacate. And I cite all these void judgment vacates. 1, United States versus Rogers. City of Lufkin versus McVickers. Fruits versus Crew. People, ex-rel, versus Village of Lake Barrington, Illinois. That's part of our precedence law. Here's Jaffe versus Ashner, Jaffe and Ashner versus Van Braun. That's part of our precedence law. I should win that case. Now, if the opposition, the IRS, cannot show that these cases have been overruled by the Supreme Court, they stand. If they're going to stand mute, then they're a bunch of fruitcakes and they lose. And they got to return all the property. The several questions, or the overall question addressed in this motion, is the right of ownership of property belonging to these people and property diminution authorized by law. Such property being the man's labor and wages. And I cite Buchanan versus Worley. I cite Holden versus Hardy. That is his property. Also, that's stated in Butcher's Union and a number of other cases. And so, well, it's in the brief. Because I'll refer, sometimes I'll say, see the brief in certain cases. Pollock versus Loan and Trust, to establish what existed before the 16th Amendment was passed. And then what an excise tax is, what the court ruled on excise taxes. Direct taxes, Evans versus Gore in 1920, which was 7 years after the 16th Amendment. Stanton versus Baltic, Brushaver versus Union Pacific, Peck versus Lowe, Eisner versus McCumber. Then I go into another paragraph. But see, that is what you've got to do. You have to do a paragraph and then cite one or more case laws to back up your paragraph. It's a technique I started using, and it's pretty effective. Scares
Are we getting a copy of that?
Yeah, you need a copy. I can give you a copy. Here, let me, just don't, this is just these people's privacy. I would like to maintain it. They've given me authorization to put it on the internet, but I still would rather protect their privacy. But that's an example you could use. And then the complexity of the income tax laws may have deceived this honorable court into believing that they were liable for an income tax. Some have even contended that the Supreme Court was confused on the issue of the 16th Amendment and its effect. But as shown above, there was no confusion or misunderstanding by the U.S. Supreme Court in the above ruling. In fact, the Supreme Court rulings displayed a total consistency. And I cite gold versus gold. So that's the type of thing that you want to do. Now, in this, you come down to the bottom, and now you're going to get into an area which is called cause of action. Okay, causes of action. And you're going to name those 1, 2, 3, 4, 5, whatever. Causes of action. Now, this is an area. You might have number 1, deprivation of constitutional rights under the 2 taxing clauses of the United States Constitution. So, deprivation of a constitutional right. Okay, and then you might have number 2, deprivation of due process. So you title each one, and you'll see if you get a sample complaint. But these paragraphs are numbered consecutively with the other paragraphs. Now, in each of these paragraphs, like this, say like this is 31 and this is 42, okay, where it begins each cause of action. You will state in your first paragraph that all these paragraphs are included by reference into this cause of action. Then you will say, in this cause of action, all these paragraphs again are included by reference in this cause of action. So now you're taking all these paragraphs and tying it to that one cause of action. Oh, before we get to the cause of action, you want to state your damages. So don't forget your damages. They got to go in there. You got to have damages. If you don't state your damages, they could be emotional, property, stealing your property, could be denying you your right and freedom to work and support your family. Could be slander of your character. All these things. Now, like slander, what kind of a price tag do you put on slander? I'll tell you what, that's pretty damn high. For them to slander us and call me a tax protester or whatever they've done, or infer that I was a tax protester to my business associates or my family or whatever, that's a slander. That carries a price tag.
Called me a tax protester, right, in a motion to dismiss.
Okay, that's a slander. You tell the court that. You got to tell the court that's a defamation of character and it's slanderous. And you want sanctions against the lawyers for putting that in there.
But they weren't doing that anymore.
They're not supposed to, but they do. I tell you, these jurors are so stupid, you can't believe the stupidity that they put in their fight.
They're too big to do it. Wow, can't believe that.
What's that?
They got to take it a wacko.
Oh. That's irrelevant, Your Honor. Objection. We're going to have to start practicing when somebody makes a statement in here that is hearsay, or is false, or misleading. I'm going to ask you guys to stand up in the following days and say, objection, Your Honor. Just do it like you would in court. I will understand. And I will admire you for doing it.
What if you overrule us?
I will overrule you, and then what do you say?
Exception. I take exception to that.
And what else you say?
And reserve my
For
right
the
to
record.
appeal.
Yeah, and you
Place it
want,
on the record.
it went up, placed on the record?
Yeah, no doubt.
Right. You want the court recorder, place it on the record for appeal. Okay. So, but I'll play the judge. You just get used to the idea of objections to hearsay. You can even make an objection that if an attorney is asking leading questions of a witness, you can object to that. Now, in the court rules, it says if you are a natural person, you can ask leading questions. But attorneys can't.
So when they try and get you for asking a leading question, then you can invoke a rule that says you're able to.
That's right.
Yeah.
That's right. And show the judge how stupid he is.
Yeah.
No, I mean, I'm serious. The judge is going to shut his mouth after you do this to him a couple times. You know, he's going to want to sit there and just listen, like he's supposed to be doing. Yeah. But anyway, you're going to make your objections. For instance, what if a judge, attorney on the other side makes a statement about a fact? Say, Mr. Conces did not file his tax returns. Objection, Your Honor. That is misleading and it's hearsay. There is nothing on the record to show that I have not filed my tax returns. And it's false. Because they didn't even say which tax return. But it's hearsay because the attorney doesn't know firsthand whether or not I filed a tax return or not.
Well, there's a requirement on you to file it.
Yeah, that's right. It's irrelevant because we don't know what tax return he's talking about. Is he talking about the excise taxes on alcohol, tobacco, and firearms? What kind of a tax return is he talking about? So you can use these, though, on this attorney and stand up and say that. If he's questioning a witness and says, and he makes a statement, this man had income. Objection, Your Honor. False, misleading statement. I did not have income in the constitutional sense, which is the sense that we're talking about here in this case. And that is stated in the Supreme Court rulings. We have at least 7 Supreme Court rulings defining the word income. And we also have the case rulings that say that Congress cannot define income. Because then they can define anything as income. They don't have the power to do that. The Supreme Court says so. So anytime they mention the word income, objection, Your Honor. Objection, Your Honor. No income. I've never had income. I've never incorporated myself. I'm not in a LLC. So I have no income. I receive direct, I receive wages. And according to the Code of Federal Regulations, wages are, taxes on wages are direct taxes, prohibited by the Constitution unless apportioned. You tell them that. Don't let them walk all over you. That's why I'm saying it really takes more than one day to get this down. You have to be able to think on your feet. Yeah, like second nature.
Let me ask you, if someone did have a corporation, the corporation would have to file taxes.
Yeah.
But the person who is running the corporation, would they have to file taxes?
Well, whoever's responsible to file the taxes for the corporation would have to file.
On whatever he gets to?
No.
Okay.
The tax is not on the corporate officer.
Okay.
Taxes, the corporate officer is only obliged to turn over the taxes owed by the corporation.
Okay.
Yeah, profits and gains, right. That's all in those Supreme Court rulings. Yeah. So even if corporations could set up their whole system, in fact they do. They set it up so that they earn $10 billion and they don't have any income for that year. They pay 0 taxes for that year. They set it up so that they have their junkets to Hawaii or, you know, they have conferences down in the Virgin Islands and they write it all up. Or they write off whatever they can. But they end up with no profits or gains. at the end of the year. And a lot of corporations do that.
And that's what the definition of income is, according to the Supreme Court.
Profits or gains, that's right. But it doesn't include the wages that people receive that are not corporate officers or, you know, not incorporated themselves. What are we looking at time? We're almost closed. Now, let's just go over this real quick. You got your cover letter, you identify yourself, you identify the defendant, you establish the jurisdiction of the court, you have paragraphs on facts, paragraphs on law, you want to back up everything you can with court cases, then you state your damages, then you get into your causes of action. Now, it could be a violation of like for instance, a deprivation of a constitutional right. That is in the United States Code, and that's in a criminal complaint. So you could say that your cause of action, one of these causes of action was 18 USC da-da-da, section so. So that could be a cause of action separate. You could do it on the basis of a constitutional violation of your due process. You could do it on a number of bases. Anyway, you're going to have to think those out. And then at the end, down here at the bottom of the thing, you have your prayer. They call it a prayer. To the court. You can actually, they used to say, wherefore plaintiff prays that this honorable court issue, and you tell them what you want the court to do. You may want to ask the court to dismiss the defendant's motion to dismiss the case. You want the court to proceed to discovery. No. This is your original complaint. That wouldn't be that. That would be a prayer asking for the damages. Asking the court to issue rulings and to proceed to discovery and trial. Because you want a trial. You also make a demand for trial. Don't forget that part. On your cover page, demand for jury trial. Specify it in bold letters, right at the bottom of your cover page. Demand for jury trial. Because what's going to happen is they hate to go to jury trial. These lawyers hate to go to jury trial, especially if you got a good case and you know how to present it in court, and you're a pro se. The jury's going to be favorable to you.
And then you also invoke Rule 37 of the Federal Rules of Civil Procedure. It's a civil case that says your right to a jury trial is inviolable.
Well, you could...
As a plaintiff?
No, yeah.
Yeah, as a plaintiff,
Yeah.
yes. Oh, yes, you demand jury trial. You don't ask for
I'll do that.
it. Okay, there's a difference between a request and a demand. Always demand a jury trial. So that could be a paragraph right in here after jurisdiction. Plaintiff demands jury trial, and you cite the court cases that say that you are entitled to it. And then at the bottom, you might even put in that court case, that 2002 case, about the court is obliged to present all the findings and conclusions. Just as a notice to the court, after your prayer. You put a notice to the court down here, label notice to court in South Carolina case.